Good morning, Europe, and good afternoon, Southeast Asia. Welcome to our webinar brought to you by the Southeast Asia IP SME Helpdesk project and EuroCham Laos. Today's webinar, we will be speaking about intellectual property rights in Laos. And before we go through the agenda, a quick introduction to the two moderators of today's webinar. It will be myself, Nora Bihari, Project Manager of the Southeast Asia Helpdesk, and the Q&A session will be handled by my colleague, Benoit Tardy, IP Business Advisor. And the housekeeping rules very quickly. So first of all, you will be all muted during the session to ensure that there is any kind of background noise. We advise you to use the gallery view option that you can set up on your screen based on the instructions here. Very importantly, please feel free to type in any questions you may have throughout the presentation, and our speakers will be answering you in live during the Q&A session. And today's webinar is recorded, so we will share with you the recording later on. And today's webinar speakers will be Ms. LounglavanhVongxay, External Relations Officer from the European Chamber of Commerce in Laos, and Dino Santaniello, External Expert of the Helpdesk and Head of Tilleke Gibbins, Laos. And now, before we get started, just a quick overview about the agenda. So after the presentation of our project, you will also hear a few words about EuroCham Laos. Then Dino will walk you through about IP updates in Laos, and then we will close the session with a hopefully interactive Q&A session. So on the next slide, you can see, if you missed the video just 2 minutes ago, a quick overview about our services. So the Helpdesk is an initiative of the European Commission to support small and medium-sized enterprises to protect and enforce their intellectual property rights in relation to Southeast Asia. All services that we offer are free of charge. How can we help you? You can contact us through the helpline service and receive an answer to your IP question within 3 working days. You can check out our country fact sheets on the website and other IP materials that we have. Join our workshops free of charge.
I think we lost Nora.
Yeah, apparently we lost Nora, so I will just take over. Technical issue. Sorry.
Yeah, I'm here. I don't know. I was kicked out. Yes, so I was just saying that we've now passed the floor to EuroCham Laos for a short intro.
Okay. Good afternoon from Laos. First of all, I would love to inform that unfortunately, our Executive Director, Ms. EuroCham, is not feeling well and couldn't join us for today's session. So I am LounglavanhVongxay, an External Relations Officer, on behalf of our Executive Director and on behalf of the European Chamber of Commerce. Will provide you a brief introduction about the European Chamber of Commerce in Laos before we jump to the next session. Next slide, please. Yes, the European Chamber of Commerce in Laos is officially known as the only official representative of the European business community, which was first established in 2011, and last year, 2021, was marked as our 10 years anniversary. And we were established under the umbrella of the Lao National Chamber of Commerce. One of our main missions is to make Europe the preferred business partner of Lao PDR, as well as to represent and advocate for the interests of our members. Until now, we have almost 100 members, starting from junior members, SME, corporate, silver sponsor, gold sponsor, and platinum sponsor, respectively, in many different business categories. By being a member, you will be able to access to more than 2,000 local, regional, and global business contexts. We also offer several services for those who want to bring their business into Laos. We could be like an entry point for you to the Lao market. We also offer you the legal information, market survey, business matching, training, seminar, networking events, or the organization of delegations and advocacy regarding business concerns and business issues in order to provide you a better business environment. Next slide, please. By coming to us, we will be able to support you in terms of market information and market research. For those who want to bring the business into Laos but have no idea about the latest trend of business in Laos, please feel free to contact us. And we also offer you the client identification and business matching for those who have no idea about the client in Laos or looking for a partner in Laos. And the recruitment service is also one of our services. For those who are interested in our service or would love to know more about us, please do not hesitate to contact us through several channels showing in the slides. And here comes the end of my presentation. Thank you.
Thank you very much, LounglavanhVongxay. So now we will move on with the IP part, and we will start with a very small game where we would like you to participate. So 2 questions for you, and you need to select the suitable option. So the first questions will be, in Laos, is it possible to file a trademark application using the e-filing system? A, yes. B, no. C, I don't know. So please take 30 seconds, think about it, and let us know what you think. And then we will see the result. And the second question that you can also at the same time select, in Laos, is it mandatory to register or at least notify a franchising licensing agreement before the Department of Intellectual Property Rights? A, yes. B, no. C, I don't know. Don't worry, the presentation today will give some input on these questions, so you will not stay without an answer. You will find out later if you were right or not. I think we should now share the result and move on with the presentation. Yes, interesting. So for the first question, 33% said yes, 24% no, and 43% is not sure. So I hope those who are not sure, they will be sure by the end of the presentation. And the second question is, yeah, 43% yes, 14% no, and 43% I don't know. So I think, Dino, you have your homework now. And yes, I would like to give the floor to you now, and please update us on some interesting information about IP in Laos. Thank you.
Okay, thank you, Nora. First of all, can you hear me clearly?
Yes, I can hear you.
Okay.
And I also see your slide perfectly.
Okay, fine. So maybe I can set my slides to the agenda directly. So thank you again for allowing me to participate to that webinar. So as you have heard, my name is Dino. I'm heading Tilleke and Gibbins office in Laos for about 5 years, but living in Laos for almost 7 years now. So I have a little bit of experience regarding the legal framework, but also the local context, which can help a lot in solving legal issues as well. And we are handling a lot of things, not only intellectual property, but today intellectual property is our topic. So we do a lot of intellectual property work, from registration to the enforcement. And I will be happy to share some of the insight about my experience in the country. So while trademark registration is pretty straightforward in Laos because of the good regulatory framework, I believe, when it comes to enforcement, it's a little bit more difficult. So I will be here sharing some of my thought and experience in that regard as well. So without further ado, about the agenda, briefly we'll make an introduction about the regulatory framework. Then speaking about trademark registration, parallel import, and how we may be able to prevent it, but I would like to manage some expectations tough in Laos to actually prevent parallel import, but there may be some way to do it. Franchise and license agreement. For anybody who wants to set up a franchise in Laos, do I need to register my franchise agreement, my license agreement, as we've just been asked earlier on the poll, but are there any other steps, requirements? And finally, we'll be here to speak about options available for trademark owner in regard to protecting their brands. One more thing, Nora, if you feel like I'm getting too slow, don't hesitate to push me a little bit 10 minutes before the end of the webinar. I'm very okay with that. Okay, so let's go for the first part, introduction about the IP regulatory framework. So I just wanted to show one thing, that we may think Laos as a isolated country, landlocked country, but on the IP side, it's pretty, the exposure that Laos has on the international scene is very interesting, and thanks to all those international treaties to which Laos is actually a contracting member. So that is something that is very useful for foreign brand owner coming into Laos, because it's not like they are coming into a known country where they have no reference about what type of regulatory framework may be used, because international treaties also apply to Laos. And most importantly, the one that is used on a very daily basis is the protocol relating to the major agreement, which allows practitioners from the contracting members to register trademarks in Laos from the country where they do practice. And that's a very interesting agreement. I think the dynamic is very interesting over the years, and we've seen a big increase of registration through international registration in Laos. And I think it completely fulfilled the purpose of the agreement. Next, I wanted also to share a little bit about bilateral agreements available in Laos. So what are bilateral agreements? It would be an agreement between two countries, so here Laos and another country, which usually would enable the registration to go faster in the event that the registration was already granted in one of the countries. And I will take just a very practical example about the cooperation in the field of trademarks and geographical indication. So it's a bilateral agreement between Laos and Cambodia. And the GI, geographical indication, Champagne, was actually registered through that bilateral agreement. And that was very useful because since Cambodia already granted the certificate in Cambodia, then the examination process in Laos was way faster, and works were just easier for the Lao examiner, and specifically on issues which can be very technical and very new also in Laos. So it saved a lot of trouble, I think, during the examination process. So there are also other bilateral agreements, but we'll not be mentioning these. For South Korea and Vietnam, I need to check on the latest update. There may be some updates in that regard also as well. So moving forward, now what we use here in Laos on a very daily basis is the national regulatory framework. So first of all, the most important piece of legislation is indeed the law on intellectual property, which was approved at the National Assembly in 2017 and in force since May, June 2018. But as always, or very often in Laos, the sole law is not enough. So this is why usually there will be subsequent regulations in order to explain, in order to implement property the law. And it's not just about IP, it could be about even investment, corporate law. So the law on intellectual property is just on the same page in that regard. So there is what we call afterwards decision, which is the literal translation of kotok long in Lao language, but it could be also instructions. Sometimes it could be also decree, it depends. So when it comes to IP, it's a decision issued by the Ministry of Industry and Commerce. And relating to trademark, for instance, it's not possible to provide a clear advice relating to trademark without having a look at the decision on trademark and trade names. The law on intellectual property gives a very comprehensive set of protection, but lack of details, especially in the for the registration of the trademark. So whenever we want to provide an advice, a clear advice, detailed advice, we must have a look at what the decision says. And it's exactly the same for the other areas of IP. And finally, about the regulatory framework, I wanted also to talk about the supervisory authorities. So here I suggested 4, it could be more, depending on the type of good we are talking about. But the most important one is the Department of Intellectual Property. So their role here is pretty much for the registration. They could be also involved in terms of enforcement, but most likely, I mean, most of the time, they will be treating registration of any type of IPs. It could be patent, industrial design, copyrights, notification of copyrights, or registration of trademark. It goes through the Department of Intellectual Property, which is now under the Ministry of Industry and Commerce. It was not the case before. Before, it was under the Ministry of Science and Technology, which was simply dissolved. And I think it's just in order to simplify a little bit and streamline the work better between the ministries. So the Ministry of Science and Technology was dissolved. Now the Ministry of Industry and Commerce take the lead on IP, which is good, I think, because the Ministry of Industry and Commerce, as we can see below, is also involved with the Internal Trade Department, and in terms of consumer protection. And many times consumer protections involve also protection of IP trademark against counterfeits. So Internal Trade Department will be involved in terms of seizing a lot and protecting consumers. So they will go on the markets, shops to see upon evidences to see what type of goods, if counterfeit goods are sold. Same thing for the economic police, because since the new penal code, which is very available since it was published very recently, IP infringement is also a criminal offense. And the person's author of a IP infringement is actually liable to imprisonment also, as well as fine. So it's totally permissible to go to the police and complain about IP, which is a huge improvement, even though maybe I will explain a little bit later. In terms of enforcement, here we're talking about police officer not very well aware about what is IP, what is at stake. So sometimes I think the enforcement process is still a little bit slow in that regard, but it's not natural. It's something very nascent also as well. And Customs Department, as you may guess, it is possible in Laos to stop goods at the border in order to prevent the distribution of counterfeit goods even before it reached the Lao marketplace. So very effective, but we will see there are some good side and less good side in regard to enforcement with Customs Department. Again, like economic police, I think we need a lot of improvement, but we're on the good way, on the right way. So just I'll try to be brief on the registration process. 5 steps. I think I'm right. Yeah, 1, 2, 3, 4, 5. 5 steps. It goes from the filing through the granting of certificate, and in between formality examination, publication, which allow people to actually propose to someone who wants to register a trademark, which may be similar to a trademark already existing, and also substantive examination, which is here a substantive examination made by the examiner of the Department of Intellectual Property to see if the law is actually infringed, and eventually the granting of certificates. So let's see in more details. So what can be protected in Laos? Here I say words including, it could be also logos, personal name, letters, numbers, figurative elements, 3D image, motion animated pictures, product packaging also as well, which can ease a lot for the authorities to actually proceed with any counterfeit if we can see that the packaging was actually copied, for instance. or any combination of colors. So here, as you can see, there is a wide range of words or items that can be registered as a trademark. And we can see what we call non-traditional trademark, 3D image, motion, animated pictures. But that's very interesting, and that's very new. I mean, now it's less new, but it was new at the time where the Law on Intellectual Property of 2017 was published on the Lao Official Gazette. But in practice, as far as I know, for us at least, I don't think we ever handled any non-traditional trademark registration in Laos for two reasons. First and foremost, we never maybe received an inquiry, or we did very few. And secondly, the last time we talked even with the authorities, we understand that there, it was maybe some month ago, but they were not ready at that time to actually take care of such kind of registration. So it's possible by law, but again, in practice, there may be some issues. So one thing that I want to say is you're not required to register your trademark to distribute the trademark goods in Laos, meaning that the mark cannot be registered, and it's perfectly fine. You can distribute your goods, you can sell your goods in Laos. However, you will not be protected. So if someone registers the mark that you're using, you may have some issues later to try to cancel the registration done, because in Laos is the first serve basis. So the first person to register a trademark will be granted with a monopoly over that mark. And it's very difficult, I think, afterwards to ask for the cancellation of it. So usually what we would recommend and what we witness from our clients that before they expand to Laos, they start to register their trademark, and then they start selling the goods. That's what we see. Some marks do not need to be protected, is what we call well-known marks. For instance, those marks that are so famous in Laos that they have the same protection as those registered marks. But there is a problem here, is that there is no list of well-known marks. So sometimes a mark can be well-known maybe in Japan, in Korea, China, but not known in Laos. And according to the Lao law, the mark must be well-known according to the Lao market. So it doesn't mean that your mark is, if your mark is famous in Japan, in Europe, in US, but it's not known at all in Laos, we could make maybe a poll through the population to see if they know that mark or not. That mark will not be considered as a well-known mark. So there is a risk to assume that the mark is well-known and start to distributing the mark without registering it first. Filing a trademark, so required documents, very straightforward, application form from the DIP. If you use an IP agent in Laos, which you must if you are based offshore, or a law firm, you must have a power of attorney, specimen of the mark, the detail of the list of the good of the service. So here we're talking about the class. So each mark will be actually linked to what we call a class. So a mark will be protected according to the class the mark belongs to. Okay, let's say there is a car, the brand of the car is orange. I may register the trademark, the mark orange in the class pertaining to cars, so that I will be able to protect my brand orange in the automotive industry. That's how it works. Meaning that if there is a, I don't know, maybe a service provided about marketing service with the same name orange, but in a different class, most likely there is no here infringement between the two trademarks. So it's just very important to understand that when a mark is protected, it's protected for a very specific good or a very specific service also as well. And official fee, it's a little bit, I think, not precise regarding to the USD. It should be more like 200 now. Actually, there was an increase of fees this year and a decrease when it comes to multiple class registration, about $80. But there are official fees to be paid, and they must be paid at the time we do file the trademark application with the Department of Intellectual Property. And here you have your response to the poll. Wonderful. So there is no e-filing system in Laos. Sorry for that. The Department of Intellectual Property is working very hard on the issue. It should have been ready already, I think. I think here the issue is more about IT servers and how to implement it. it should be ready anytime soon. So hopefully we can have it very soon. It would have been very useful for during the time of COVID, for instance, but it's not the case yet. Formality examination. So here the officer will just go through if we have submitted the correct document. The examination time takes about 60 days. Not about, it takes 60 days actually. Then it comes 15 days after the formality examination is done, there is a publication. And here, this is something also that is only detailed in the decision on trademark. So we provide the possibility to third parties to oppose to a trademark registration. So if one thinks that the trademark that is being registered or under that is pending for registration may actually infringe their right, they have the possibility to oppose. And actually anybody can oppose, not only an interested party. So it's possible here before the trademark be registered to oppose in order to make sure that the trademark will not be registered. So the good news also as well is that the website now it's been 2 years. I think it's fully in operation. The website of the Department of Intellectual Property publish regularly a gazette where we have the publication of those trademark we can oppose. So the opposition is open for a period of 60 days, which can be extended, as you can see on the right. And if within 60 days and nobody responds, the DIP, they will still consider actually the opposition, but according to the information they have in hand, but they will consider it anyway. If the opposition stage is passed, then we have the substantive examination. So here is just about the examiner of the Department of Intellectual Property, and they will see if the trademark breaches the law, if the trademark is just a sign that is not descriptive or a sign that is too generic to be used, to be granted a monopoly over, and to prevent everybody from using it. So this is what the officer will check. And they will check also if the trademark is, we say, ineligible by law, deceptive, contain name of living person without their approval, contain name of even nations without the approval, or maybe contrary to social order. So if you want to register a trademark, which is maybe a bad word in English, most likely the mark will be refused, denied registration. Oh, I think I went, sorry for this. So here we were talking about trademark registration, substantive examination, and here is what we have actually. Now the certificate has changed slightly. They're a little bit different, but this is what we have when the Department of Intellectual Property agrees. So there is what we call the second publication on the Lao official, the Department of Intellectual Property website. And it gives here the opportunity for the owner of the trademark maybe to correct, amend any mistake that have been on the trademark certificate. But here it means that the trademark is already registered. So after this time, other parties may have 5 years within the registration date of the trademark to actually ask for a cancellation. So it doesn't mean that it's not possible to cancel the mark when it's registered, but it may be more difficult. And you have 5 years from the registration date. So now, I think we have about 10 minutes maybe or so, right, Noah? Okay.
A little bit more, 15 minutes.
Okay, good. So about parallel import. So first of all, what is parallel import? That's something that is very, I would say, common yet in Laos, because Laos, and specifically the capital, is very close to the Thai border and very big city. So basically, it's when someone from Laos goes to Thailand, buy lots of goods from a specific brand, and come back to Laos to sell it. that's one side of parallel import. And in Laos, many brand owners actually are complaining about that, because those goods do not reflect the real sale that the Lao entities is doing. And it harms business in Laos that have their local subsidiary in Laos, but also it harms Lao importer, because it's very difficult then to have an exclusive agreement with someone whereby a trademark owner would grant exclusivity to one importer in Laos to import a specific type of good. It's not true for all type of goods. For instance, for medicine, there is by law a registration that must be made with the Ministry of Health about a very specific importer that is the only one that can import said medicine. But for general goods, it's very difficult to implement. And this is the problem we are facing in Laos. So it caused a lot of trouble for local business and also local importer. And by law, actually, it may be possible to prevent parallel import. According to the Law on Intellectual Property, Article 58, there is a provision that says sale or advertising of goods bearing the mark or the use of the mark in connection with services or the importation of goods bearing such a mark can be prevented by the trademark owner. I think I may cut the provision a little bit too early, meaning that according to the law again, if a trademark owner wants to prevent the sale or advertising of the goods according to the goods in Laos, it can, because the law on intellectual property in Laos provide that possibility. But in practice, it's pretty difficult to enforce. First of all, I think there is a lack of communication between each ministry. So in Laos, IP is for the subject of the Ministry of Industry and Commerce now, but Customs Department depends on another ministry, which is the Ministry of Finance. And I think Customs Department sometimes not very well aware about all the provision of the IP law and how to implement it also as well. So it causes trouble to actually implement effectively that specific provision. And secondly, from our experience so far, the authorities, they have more some kind of economic reasoning. They believe that it's good for the business if people go to Thailand, buy lots of goods which are discounted, maybe those big supermarkets, comes back to Laos and sell it cheaper than the actual trademark owner having a subsidiary in the country, because they think that for the population, it's a benefit. They can buy good cheaper, which is good for the population. So this is why, even though the law provides the ability to prevent parallel import in Laos, in practice, it's very difficult. And there may be some other way to prevent parallel import rather than just relying on this provision. First of all, as I said, for some goods, the importer must be registered. It's the case, for instance, for car. In Laos, it's not possible to import a car for sale if you don't have an agreement with the car manufacturer abroad. So that's one thing. Same thing for medicine, for instance. There is a license holder in Laos, and he is the one to have the authority about that medicine for a period of 2 years of the registration and 2 years of since the time the license is granted to him. So that importer in Laos can take action and say, he is the exclusive distributor, importer, and he is not happy to see someone else importing and distributing those goods. But it's not the case for daily products. Food, for instance, it's very difficult to speak with the authorities and to try to implement that provision Article 58 in the law, the law on intellectual property. But I think here, this is where there is a lot of investigation that must be done first before taking any action. First of all, we see that those parallel imported goods, sometimes they don't have the correct labeling, which must be made in Lao language. So accordingly, if they are selling those goods in a foreign language, we have a possibility here to request the assistance of the authorities to seize those goods and to withdraw those goods from the market. That's something. And the other thing also as well is about investigating about the product, specifically if those products have duly paid the customs duties or any tariffs, that it should be the case. If not, then we're also entitled to file a administration remedy, let's say a complaint, with the Ministry of Finance Customs Department to ask them to seize the goods. But it requires investigation before we are sure of this. The other also, the other thing that we can do sometimes that some products are misdeclared in order to pay less tax, customs duties also. And if it's the case again, but this requires a lot of investigation, maybe from the country of origin where the goods are imported from, then we can take action again with the customs department here and to let them know that, notify them that there are some goods which we believe are misdeclared. We need to provide them with some documents, and so they can take action and seize the shipment at the border. So that's things that we've done before, and it works well, but it requires a lot of investigation and lots of time. It's very time consuming. So these are, I would say, labeling. Now the officers are trying to implement more and more about the labeling of product in the Lao language. And we've seen that in some instances it was very useful for us. Again, sometimes we witness also as well is that the implementation of the law or those recommendations from a province to another may differ. So this is where you need to know who you need to contact: police, customs department, Ministry of Industry and Commerce, who is more attentive to those issues and may ease the communication between the officer in order to implement those recommendations, which are based by law. But according to an implementation of the article we've seen just before here, 58 of the law on intellectual property is still very difficult, I think, and we need to rely on more. Franchising in Laos. So if I want to set up a franchise in Laos, what must be done? Do we have a specific law or not? And the response, the very easy response is no. There is no standalone franchise law in Laos, and we'll rely on the common rules of the civil code about the formation of contract, performance of contract, also the law on notary, the law on intellectual property, and other laws depending on the nature of the franchise that we are talking about. So regarding to the civil code, is just the simple rules and the common rules of contract only. So people, the purpose of the franchise agreement must be legal. We cannot agree about selling illicit drugs in the franchise agreement and then expect to implement it in Laos. Indeed, it would be void, basically. The person must be also capable to contract and voluntarily sign the contract also. So that's the very basic, I would say, rules relating to the formation of a contract in Laos, and that applies. So basically, it's just a contractual agreement between two persons. There is no typical here, there is no specific registration for a franchise agreement. I also mentioned the law notary, and sometimes it's quite not clear because the law notary actually encourage people to register their contract with the notary department of the Ministry of Justice in order to have the contract being recognized as fully enforceable towards third party and also the Lao People's Court. But the civil code does not have such a requirement, and the civil code was issued recently, so we think that the provision of the civil code prevail on the law notary, and the law notary only encourage people to register with the notary department in order to provide more legal grounds on the enforceability of the agreement. So it can be good to notarize the agreement with the Ministry of Justice Notary Department in order to ensure, because when we notarize a contract in Laos, we have one officer from the notary department which ensure that the law is the franchise agreement is in line with the Lao law. So basically, when we have the notarization done, it means that the contract is in compliance with the Lao law, and that's something that we can use if there is any dispute between the parties about maybe one specific provision when one may say that the provision is not in line with the law. So that may avoid those type of issues. But one thing is that in order to notarize an agreement, you need to translate it. So if we are talking about the master franchise agreement, which can be quite consequent, the cost of translation sometimes is something that has our client to think twice before going to the notarization. And indeed, the law on intellectual property, because it's about franchise agreement, will be about protection of IP. And here, actually, it will rely also on another type of licensing. Are we still okay, Nora?
We are still okay, but we should move to the Q&A in 5 minutes.
Okay, fine.
You.
So about the franchise agreements, all those non-compete clause can be added in Laos as long as they are detailed enough and not too broad in some sense about geographical maybe area, and they do not impede too much the competition. It's fine. Damages, liquidated damages are not recognized in the Lao law, so usually the damages will be all the time commensurate to the actual damage. So it will not be able. It will be very difficult for the judge to provide damages which may be more than what the actual damages was. The governing law, by law, Laos allows people to have the contract governed by a foreign law. But what we see is that it may be difficult to actually implement the contract before court if the contract is handled by a foreign law. And sometimes we've seen some instance where the court refused to actually treat the matter which a dispute arising out of the contract which was governed by a foreign law. So registration of the franchise agreement, I would say no, not for the franchise agreement, so to speak, but there is a licensing agreement which must be, it's when one gives the authorization to another person to use a trademark. Here we can have a short form license agreement specifically between two people, to one where one would agree someone else to use the trademark. According to the law on intellectual property, it's mandatory, but actually there is no sanction on this. And if it's not, according to our discussion with the Department of Intellectual Property, the fact that the license agreement, or the short form of the license agreement, is not notified or registered with the Department of Intellectual Property, it does not deprive the authorization to use a trademark to another party. It's just that the licensee, will not be able to take any action on behalf of the licensor, and that's it. So there is, by law, a licensing agreement that must be registered with the Department of Intellectual Property. In practice, not every time it's done, and the sanctions are unknown so far. So just very briefly, Nora, so here are just the option available whenever someone wants to enforce their intellectual property rights. Cease and desist letter is just a letter written by the trademark owner to the party infringing the trademark. And this is what we recommend at the very first stage. So I think this is a very good way to try to tackle issues and to try to protect trademarks. The trademark owner must inform first the infringer, and sometime even at the court they will be very attentive if some cease and desist letter was sent before, if there was any person that tried to solve the matter amicably. Civil action, indeed, we can take injunction to stop infringement, but I have to say it's very rare yet in Laos. It doesn't happen often in regard to intellectual property. And one thing is also because the judges are not very familiar with the IP. So most of the time, all the dispute relating to intellectual property will stop at the administration level. Most of the time, people will go and complain at the Department of Intellectual Property rather than to bring the matter before the court. Criminal action, I just talked about it. It's possible not to file a complaint with the police because IP infringement is a criminal offense. And that's something we encourage because it's very effective. As we've seen, the police officers tend to be more and more proactive, but at the same time, not easy to enforce in every part of the country. So here there is a lot of education training that must be done. And customs recordal. So just maybe 1 minute on that. In Laos, it's possible to actually we say in our language, we say to notify to the customs about a specific trademark, where we ask the officer to be aware, attentive to the shipment regarding to that very specific brand. So it's possible to actually register, because that's what it is in fact, with the customs department. But in practice, what we've seen is that if after the registration for a customs recordal is made, there is no follow-up actions from the trademark owner, meaning that there is no investigation from the country of origin where the goods are exported. And if we don't give the officer in Laos particular tips about coming shipment, the customs recorder alone will be not very effective. So it's good, then we need to follow up in order to have more investigation, to provide more information to the officer to take any action. And I think that will be its administrative remedy. So like I said, we can file a complaint with the Department of Intellectual Property in order to take action. So it could be through a mediation first, but also it can be in order to ask for a redaction. So here, when we need again to investigate a lot, document our filing, our complaint a lot with the Department of Intellectual Property. And if the Department of Intellectual Property agree that there is indeed a infringement, then they can actually, there is a committee that is set up, which actually reunites also police officer. And then we can plan for a redaction strategy and a redaction plan. And that's something that occurs regularly in Laos. So it's not even easy in all the provinces in Laos, but that's something that can be done. Although it requires, again, investigation, lots of investigation time, and sometimes depending on the authorities, it may be more or less easy to implement. But that's something that is, again, something possible in Laos. So sorry for Nora if I exceeded a little bit the time, but now I'm ready for the Q&A session.
Yes, thank you very much, Dino. It was a great presentation, and it's difficult to keep control over the time. So I think you still managed quite well. So as I mentioned at the beginning of the presentation that we had a small game, we also want to replay this game to see if there is any difference in your answers. So just very quickly, you already know the questions. If you change your mind regarding the possibility to file a trademark application using the e-filing system in Laos, yes, no, I don't know. And the second question was that if it's mandatory to register a franchising licensing agreement before the Department of Intellectual Property, yes, no, I don't know. So we gave you 10 seconds because we want to progress with the presentation, with the questions. Yes, so let's show the result. Yes, okay. Yeah, it's actually it's funny. The I don't know disappeared. Now everyone is pretty sure that it's a yes or a no. Okay.
And I'm just jumping in because the second question was a bit tricky, as it was explained by Dino in the presentation, that it's only the licensing part that is mandatory. But I would say, but maybe Dino, you can comment on this, but it's always better to register any kind of contract before any IP office, just for third-party information. So this is like a general recommendation.
Yes, Benoit, indeed. So what is very important, actually, what is mandatory is, and I call it a licensing agreement just to make it different from franchising, but I agree that even the terms are confusing because sometimes we may speak about the franchise agreement and speak about the license agreement the same, depending on the jurisdiction. But what is mandatory under the IP law is that if I want to use a trademark of someone, the trademark of someone or someone else in Laos, we must have that licensing agreement between us two. And we must register that agreement with the Department of Intellectual Property. But the Department of Intellectual Property doesn't care about the whole master franchise agreement. So no need, and they will not accept it anyway. So no need to have the master franchise agreement, which will set out so many, which will tackle so many terms between the parties, and which will frame the whole business relationship between them. The Department of Intellectual Property doesn't want to read that, but they just want to know the very information about what trademark is authorized to be used in Laos, and what are the key terms. That's why I was speaking about the short form agreement. We do not need to have a specific licensing agreement signed by both parties, but we can draft a very simple short form agreement with the Lao Department of Intellectual Property, like 2-page, 3 pages, it depends, and register it with them. The thing which can be also a little bit costly is that first, I think there is also a necessity to have it translated in Lao language, even the short form. And second, by application is one trademark. So there is official fee are not very high, but if you have 100 trademark, it's the case in some jurisdiction when people must register their licensing agreement, it can actually start to cost. In addition to that, there is also the professional fee of the lawyer involved, because the lawyer will work on that. He will, so the trademark owner will incur more fees. So it can be sometimes something that have people reluctant to register the licensing agreement, but we encourage because the law says so anyway, even though in terms of sanction, there may be none to date.
Thank you. Very clear, Dino. So we received a couple of questions on the chat box. Thank you very much for sending us these questions. The first one is a bit tricky. It's, are there any free of charge for IP registration? So I guess no, unless there is a specific incentive or pro bono action from a law firm. But for example, for us, the IP Helpdesk, we only provide free advice, so we don't help for the registration process. Same would be, I think, for Dino with the law firm Tilleke. So let's jump to the second. The second is related to NFT and registration, non-fungible tokens. Can NFT help IP registration? For this, I would more make a comment, maybe instead of NFT, maybe more blockchain for securing, having like a more like intangible information blocked in time in a specific server, in a specific, well, but NFT, I don't see the relation, but maybe if you want, Dino, to add something on this question with NFT.
Yeah. So this one and the one before was not maybe just about trademark, right? It was about, are there any IP registration free of charge? Is it?
Yes, correct.
Okay, so just to be clear on that, yes, I would say because copyright in the Lao law, you do not need to register a copyright, and I guess it would be the same in Vietnam and most of the countries where we're all in. So as soon as the work is created, then there is a protection that is here already for a certain period of time, depending on the type of copyright we are talking about. But then we do not need to register. But it could be made what we call a notification with the Department of Intellectual Property, because if there is no notification or tangible proof, then it's difficult sometimes to prove who is the author of the copyright. So what can be done with the Department of Intellectual Property, even for copyright, is to notify. Now, when we talk about trademark, no, we have to pay official fees. Our law firm, we do a lot of pro bono work, but usually we wouldn't pay anyway official fee on behalf of the person we are doing the pro bono work. And as far as I know, the Department of Intellectual Property, even for local people, they don't have any specific scheme where they would authorize, I don't know, local farmer to register any trademark for free. And that's why also the official fee in Laos are still low, I think, still low, because they know that they cannot provide two different types of fees to foreigners and to local, because it would infringe some agreement that they have in international treaties, so some kind of discrimination, which may be very a sensitive issue. So at the same time, they would like maybe to increase the official fees so that they can have a better budget at the Department of Intellectual Property, but they try to make also registration accessible to the local population. So no, official fee must be paid anyway.
It's the same scheme in other countries also. Sometimes the IP office are displaying different official fees if it's a big company or just an SME. Well, just to comment.
Sorry, because then I just realized I didn't answer about the NFT. So the NFT, that's what I understood also as well. How do we have some kind of technology used to secure and to make the proof of ownership of the IP asset in Laos? Is it something available in Laos? No, I wish it was. So as you've seen, we don't even have the e-filing yet, but it's coming, I'm sure, this year. But it's something that is not yet here. So blockchain, why I do believe that's great, and not just for IP, would be great even in Laos for land registration issues, which is sometimes very, very complicated because everything relies on paper and the inventory sometimes is not very good. So I do hope that very soon the Lao government will push on blockchain, as it's the case in some other countries in Europe, even in Africa. And so I hope so, but for now, no. So we don't have an e-filing system yet.
We will follow for the e-filing system. Two very quick questions because we are almost at the end of the time. Is it a must for a foreigner to file application through an IP service?
Yeah, if the foreign company wants to register a trademark under its name, it's mandatory. They must go through an IP agent or law firm. And even for the law firm must be approved by the Department of Intellectual Property. So it's not because we are a law firm or someone, has a law firm in Laos that they can actually proceed with registration. At the time where the law firm is establishing its law firm in Laos, incorporating it, they must also seek a specific authorization from the Department of Intellectual Property, even though there is no certificate. But then the Department of Intellectual Property, they have a list of practitioners. And for instance, our firm is indeed among the list, but it's not the case for every law firm.
Okay, thank you. I have just last one. Does the DIP have a huge backlog with the number of applications currently? How is it approximately? If you have any idea?
No, so I don't have any idea. But first of all, I have to apologize. I just realized that in my slides, I don't even speak about the number of years of protection. So it's 10 years of protection. And now when we talk about the time frame, either the decision on trademark or the law on intellectual property, I think they took good care not to mention any commitment to any time frame where the trademark would be registered. So there is no, by law, there is no time frame where the trademark would be registered. There is no 6 months, there is no 5 months, there is no 2 years. Now in practice, what we can say is that usually it takes 12 months to 15 months for some time. Are there some backlogs? I guess so, but it wouldn't impact much about trademark. So trademark, we know it's 12, 15 months, around that, sometimes earlier. When there is a problem, it could be later, but less and less it's happening. But for patents, yes, I believe that's something that is more sensitive in Laos in terms of knowledge, technical knowledge. It's another level, I think. And we know that there's a lot of some backlogs of patents stuck for some time in the IP registration system. But for trademark, I think we know it's 12 to 15 months. That's what we expect. So there may be backlogs, but not about the registration themselves, but more about the opposition. Because of the Madrid Protocol, even, I'm sorry if I'm a little bit lengthy, but even for law firm, I think our work shifted a little bit. At first, we did a lot of trademark registration. Now we have less, maybe trademark registration, but what we have more, it's opposition from people living in Europe, US, Japan. When they see that someone is registering international trademark or a trademark in Laos from their country of origin, they can oppose to the trademark. And we've seen a lot of increasing opposition made. And here, yes, I think there is a backlog because the time frame provided in the law sometime exceeded. But we have, and it's a good thing, the Department of Intellectual Property is people are very accessible, so they try to explain what's going on. But still, I mean, there is some limited human resources also as well. And I guess here, most of the time, the time frame, I think, is 60 days for the officer to review the opposition application and blah, blah, blah. But most of the time will be exceeded. Yeah.
Okay. Well, backlog was a general trend in worldwide because of COVID. We noticed it in many countries. You enabled me to jump almost to the end of the webinar because you were discussing about the Madrid system, the international trademark system. We do have a Madrid guide. If people are interested to read it, it's downloadable for free on our website, and it's in English, very simple to understand. And here you can see at the same time screenshots of this guide. So I don't know if someone from the Chamber of Commerce wants to do a last comment. Otherwise, we can just proceed to closing this webinar. And yes, thank you very much for everyone from the Chamber. Thank you, Dino, for the very insightful presentation. Many topics were covered. And of course, this webinar will be available because it was recorded, and you will also be able to have some slides of it. If you have any question, you can ask us directly or through Dino or through the Chamber. And we hope to see you for the next webinar.
Thank you all.
Thank you.
Goodbye.
Have a nice day.